Committee on State Affairs will come to order. Good afternoon. The chair again lays out as a matter of pending business Senate Bill 1034. The chair lays out the committee substitute, Senate Bill 1034, recognizes its author to explain the substitute.
Thank you, Mr. Chairman, members. Not really a lot of changes in the committee substitute over the as-filed version. The change was in 100C011 was the main gist of it, and it's adding a definition that the assertion in a civil action injury under public nuisance tort, and it's essentially adding a definition. So with that, I move.
Thank you, Senator Middleton. Any questions on the substitute? Very well. We had completed invited testimony and heard from our resource witness, and will now open public testimony on Senate Bill 1034. And the chair calls Honorable Craig Island. Honorable B.D. Griffin. Edward Schweninger. Brian Blevins. And Joe D. Neal. We have Representative Island, County Attorney, Honorable B.D. Griffin, Edward Schweninger, Brian Blevins, Joe D. Neal. Looks like we have every seat filled, and we'll, if there's no preference, if y'all have no preference, we'll just go from right to left, my left to right. Mr. Blevins, introduce yourself. Welcome. Give us your testimony.
Thank you, Mr. Chairman. My name is Brian Blevins, members of the committee. I'm here testifying on behalf of myself and also from my experience as a lawyer practicing in this state for the last 33 years. I am testifying in opposition to the bill. And for the last 3 years of my personal practice, I have focused on representing the victims of sex trafficking. And we have been suing and representing those victims against hotels and truck stops where these events take place, and also internet companies who make this available through solicitations and connections. And one of the things that we've seen in that litigation, and part of the most compelling evidence we've seen, has been reviews of these hotels from neighborhood participants, not the actual people who are staying there, but from the neighborhoods, stating and putting forth all of the complaints about rampant crime and drugs and sex trafficking and pimps and prostitutes. And we've also seen that the impact that crime is having on their neighborhoods and the safety and their property values. And these are lawfully operated establishments, but they're allowing unchecked illegal conduct on their premises that spills out into those neighborhoods. We also see from police beat reports and incident reports again and again and again the police and the tax dollars that are being spent to police these locations where this conduct is not being checked, and doing basically what the owners of the property won't do. And so in the context of public nuisance, this is where those neighborhoods and those governmental entities can come together and bring a claim to not only stop that activity, but also to recover monetary recovery, compensation to adjust for those costs. One of the problems, and we've heard about it today, is 125 of the Texas Civil Practice and Remedies Code. Unfortunately, that's just not an adequate remedy, because it's forward-speaking, it's abatement, it's injunctive, it's not monetary, and therefore we cannot recover those tax dollars and the cost of the enforcement of these locations through Section 125. And so from that reason, we do oppose the bill and believe that public nuisance represents a needed backstop against these type of activities. Thank you.
Thank you for your testimony. Welcome. Introduce yourself and go ahead with your testimony.
Yes, thank you. Good afternoon, Chair Hughes and members of the State Affairs Committee. Thank you for the opportunity to provide testimony in opposition of Senate Bill 1034. My name is Edward Schwenninger. I'm Associate General Counsel for the Bexar County Hospital District, which is opposed to Senate Bill 1034 and the substitute. When needed, common law public nuisance is among the only means hospital districts have of seeking recovery from those who profit at the expense of public health and Texas taxpayers. Critically, the proposed bill robs Texas governmental entities, such as a hospital district, of the tools necessary to address future bad behavior. For example, even an admitted wrongdoer who facilitated the illegal diversion of opioid products and pled guilty to criminal conspiracy to defraud the U.S. government and DEA would be protected under 1034, the Senate bill, from a claim brought by the hospital district, and is immune from civil liability by eliminating a critical public health and safety tool to hold such wrongdoers accountable. Senate Bill 1034 harms hospital districts and local taxpayers. The hospital district wants you to know how we intend to use funds that we have, or will be recovered from our recent claims brought under the Texas Public Nuisance Law. We intend to enhance and expand programs for access to medication and treatment for opioid addiction, comprehensive services for families, including our most vulnerable neonate patients, and helping mothers and fathers who are suffering from addiction. Use of opioids has created a major mental health care crisis in Bexar County, and the hospital district, which works well in its partnership with the County of Bexar to support our local mental health authority, which is the Center for Healthcare Services. We have an extensive network of clinics that give us the means to address these behavioral health needs. And all of these enhanced treatment strategies are fundable through the litigation that was brought under the Texas Public Nuisance Abatement Laws. Because the 1034 works against state interest, it shifts costs to taxpayers and shifts taxpayers to Medicaid when a third party causes harm to Texas families who are impacted. We oppose the implementation of this bill. If there are any questions, I'm happy to.
Thanks for your testimony. Representative Island, welcome. Introduce yourself. Give us your testimony.
Craig Island on behalf of Texas Trial Lawyers Association and myself in opposition to both the committee substitute and the original bill. I remember Senator Betancourt said this morning about tort reform. I was elected in 1995, and that was the first year of serious tort reform. And the mantra was bring Texas into the mainstream. And over the last 28 years or so, that has happened. But if y'all adopt this bill and it becomes law, we will definitely go to the extreme and not be in the mainstream, because no other state has outlawed public nuisance. And I would like to walk through the bill and some language in the bill to make sure we understand its implications. Section 002 says that a public nuisance claim is not cognizable in this state if you're seeking relief on a condition or action authorized by ordinance of a political subdivision. What does that mean? That means a small town in West Texas could pass an ordinance that impacts the Port of Houston or DFW Airport. And there's so many cities and counties, well, cities and authorities that could be passing ordinances, and you have no idea how they are impacting. You could even elect your own city council in a small jurisdiction. A company town or a wealthy family could go and elect a majority city council and then just run through ordinance after ordinance after ordinance in a nefarious fashion, be perfectly legal and impacting everybody's rights across the state from one little town, one little subdivision. That is specifically authorized here. Next, under 02, number 2, and if you can't have a public nuisance claim if an administrative enforcement mechanism exists and addresses the conduct. But what you just heard Bexar County Hospital talk about was damages. So you could have an administrative remedy of $1,000 a day, but they caused millions of dollars of damage. And if I could just finish, Mr. Chairman, the third, or number 3, it actually says that a city or county or hospital district could not recover from a claim of a product, even if the product is defective. So this is the first time I would know that we would actually put into a statute that you could not recover damages from a defective product. And so I think that those three things are very concerning. Now, I'll wrap up with this. I'm currently involved in the PFAS litigation. And PFAS litigation is where cities, counties, and airport authorities are trying to recover for contamination and water, groundwater contamination. And in that litigation, Marathon Petroleum and Valero Petroleum have both filed lawsuits against 3M and DuPont and others for recovery. And if public nuisance is the claim of Marathon in their case, is one of them. Just think about it. If this law is into effect in the PFAS litigation, Marathon Petroleum would be able to recover for the groundwater and the soil contamination inside their fences. But yet, if that same contamination gets in the groundwater and migrates across under the fence line into the city or county or the water authority that needs remediation, that community could not recover. Even though Marathon Petroleum could recover for the damages inside the fence, the city, the county, the water authority could not recover for that exact same damage outside the fence. And so I don't think that that's a very good idea. And finally, one thing Senator Betancourt asked earlier this morning, one of his questions was, what would the impact of this be? What would happen is, even if you take the opioid litigation, what happens in national multi-district litigation is a motion to dismiss would be filed against the state of Texas claims or against Harris County claims or Dallas County's claims, because the theory of recovery nationally was public nuisance. And since we don't have a law that recognizes it, we would be thrown out and not able to participate in some type of national settlement. So there's real world impacts, and we don't even know what they're going to be in the future.
Thank you, Representative. Good afternoon. Introduce yourself. Give us your testimony.
Happy to. Good afternoon, Chairman. My name is Jody Neal. I am an attorney at Simon Greenstone Panettiere. I'm a former prosecutor, and I am in the trenches in the opioid litigation. My firm represents 46 counties in Texas, including Angelina B., Blanco, Bowie, Burnett, Camp, Cass, Cherokee, Cook, Coryell, Dallas, Delta, Dimmitt, Ector, Falls, Fannin, Franklin, Freestone, Grayson, Hardin, Hopkins, Houston, Jasper, Kendall, Lamar, Limestone, Marion, McMullen, Melam, Morris, Nacogdoches, Newton, Orange, Panola, Parker, Potter, Red River, Robertson, Rusk, Shelby, Smith, Titus, Trinity, Upshur, Van Zant, and Wood. And what I know is that the Supreme Court has told all of these counties that public nuisance is a valid cause of action that they can pursue when their community is wronged. The Supreme Court held up our case on 91As a few years ago, and we were able to litigate it. And let me tell you something, litigating against the biggest drug companies in the world is no laughing matter. You don't just stomp your foot and get billions of dollars for the state of Texas for opioid harm reduction. You have to fight for it, and we did, and it's worked. And right now, as we speak, money is flowing into our counties so that they can buy Narcan, so that they can fortify their drug programs, so that they can help first responders who are overwhelmed by the weight of this epidemic that is very real in Texas. This is not a West Virginia problem. 7 billion opioid dosage units, hydrocodone and oxycodone alone, came into the state of Texas between 2006 and 2014. West Virginia had 1.1 billion. The opioid epidemic is alive and well here in Texas, and not only that, we have a real open courts concern with this bill. The way I read Section 13 of the Texas Constitution says the right to bring, if you don't mind, may I finish? The right to bring a well-established common law cause of action, and we have all agreed that's what this is, cannot be abrogated by the legislature absent a showing that the legislative basis for the statute outweighs the constitutionally guaranteed right of redress. Our counties and their taxpayers have a constitutionally guaranteed right of redress that is directly threatened by Senate Bill 1034, and I am asking you to please vote no.
Thank you for your testimony. Introduce yourself. Give us your testimony.
Thank you. Mr. Chairman, members, I am B.D. Griffin. I'm the county attorney, elected county attorney for Montgomery County, Texas, and I thank you for the opportunity to speak today. I'm speaking in opposition to Senate Bill 1034, and for the record, the Montgomery County Commissioners Court has not taken a position on SB 1034. We haven't had a chance to bring it to them with regard to this hearing. But Montgomery County is a litigant in opioid litigation and a participant in settlements related to the opioid litigation. Public nuisance is an essential tool and is often the only effective tool for Texas counties to respond to the creation, maintenance, or adverse effects of actions that unduly and unjustly burden the community. This bill effectively prevents Texas counties from pursuing such claims without providing for effective alternatives. Now, I'm a proponent of tort reform, but SB 1034 is not good tort reform. There are no public benefits in SB 1034, only public burdens. One of my main concerns is that the bill is vastly overbroad. It's like using a sledgehammer to drive in a finishing nail. You're not going to like it doesn't achieve the intended results. The bill's statement of intent says that it narrows the scope of available public nuisance claims. Unfortunately, it doesn't narrow the scope. It removes the county's most effective tool to seek these remedies, and as written, it eliminates claims arising from, which I'm not sure, that seems awfully broad to me, just about any action that is not a criminal violation. The bill effectively cloaks bad actors with immunity for these inappropriate actions by the mere act of obtaining something as simple as a permit from a local government or regulatory agency. And we know there are even well-meaning state agencies tend to have tunnel vision when it comes to their regulations. They look solely to compliance with their respective regulations without regard to the broader effects upon the permittee's actions. May I continue? In fact, in many instances, an agency or local government must issue a permit if the application is facially correct, regardless of the effect the permit has on the community. And we all know what federal regulators do. They really do not care anything about the local communities and making their decisions. A public nuisance inflicts harm on the community at large, and the other problem, the harm continues long after the cessation of conduct. And the bill unduly restricts a county's ability to address this harm that continues even after cessation of the public nuisance or the inappropriate conduct. If a county is not able to pursue these claims, they either have the impossible choice either to raise taxes to an amazing amount or to ignore the problem and let the community suffer the effects. In Montgomery, I would like to point out Montgomery County, we have 79% of our county is not in a municipality. Even though we are the 11th largest county in the state of Texas, we have over 620,000 people. So the service burden and the health and safety burden falls on the county. And as you probably know, counties have very little ordinance making ability. So we have the service burden, but if you take away the public nuisance ability, we're not going to have an effective enforcement mechanism. And I would we are in opposition. We respectfully request the committee to be in opposition as well.
And thank you for your testimony. Senators, any questions for any of our witnesses? Thank you. Senator Middleton, go ahead.
I had one. So I see the City of Houston letter here, but it's kind of similar to the Montgomery County one. They cited the tobacco case. Did any cities or counties plead public nuisance in the tobacco litigation?
I can answer that somewhat. There were very few cities or counties who actually participated in the tobacco litigation. It was almost exclusively attorney generals at the state level. The opioid became a very different litigation. At tobacco level, it was almost exclusively attorney generals in states.
And it was record recovery, as we should have, because they were saying cigarettes are good for you when they knew better that they weren't. They're bad for you. But that was through the state level, so that did work. And then, on the cities, or I guess the counties, County Harris, their petition, they say defendants engaged in a campaign of lies, half-truths, deceptions to create a market that encouraged the overprescribing and long-term use of opioids, even though there was no scientific basis to support such use. That sounds like a DTPA claim to me, not a public nuisance. So, I mean, that's right there on the first page of their pleading. So, I mean, that's clearly a remedy available under the law right now. Outside of this bill, not impacted in any way by this piece of legislation.
And I defer actually to those who are engaged in the opioid litigation.
The public nuisance claim is different from the DTPA claim because it allows the county to bring this broader, it allows the county to address a broader form of harm. You're able to really get into harm reduction through public nuisance, whereas DTPA, the remedies are very limited. And so the counties need to continue to have public nuisance so that they can have the harm reduction ability, the remedy, the abatement to address the wrongs in the community.
I guess that gets into my second point, where maybe we're actually talking about what you believe to be inadequate laws here, that there should be more changes or increased criminal penalties or civil penalties under state law that would address that, like with the common nuisance. I mean, clearly that's not great policy to get an injunction against prostitution and drug trafficking. I mean, we want those people in jail, So perhaps the problem for that is actually that they're not being prosecuted to begin with. And that's something that we need to look at. So I'm not sure that on that particular example that abating something like that is actually good policy. We want to stop it, and we want strict accountability and tough on crime policies, right? So perhaps that's something that we're dancing around here today that we need to address. But again, that's up to the legislature to do that. And that's a remedy that's available now because everyone has a state rep, everybody has a state senator.
And as to that human trafficking element and the sex trafficking, the problem is that the criminal aspect is going to go against the criminal conduct. That's the pimp, that's the trafficker, that's the John. There's no financial recovery there. It's not going to reimburse the county through the criminal system. What the problem is that these hotels are not enforcing and they're not ruling over and preventing that criminal conduct. So that what happens is under 125, they can force that facility to shut down. In and of itself, that's a good thing, but it's still not recovering the finances that the counties and the cities have expended day after day, month after month, year after year, enforcing these locations where the hotels themselves won't enforce themselves.
I would say, Senator, that when you eliminate it as a cause of action, when you say a product or manufacturing, distributing, selling, labeling, or marketing a product, regardless of whether the product is defective, cannot be a public nuisance, you get rid of not only the cause of action, but the remedy. And when, especially in the House, when we had hospital district and counties coming and talking, they were not talking about the causes of action. They were talking about the remedies available to them and the damages they're able to recover, because I don't know what standing they would be to recover certain other elements of damages. But under public nuisance, they had that standing to recover the community type of damages, which would be gone. And under this bill, for both cities, counties, and the state would have no remedy for those damages. And I do have concerns, like you said, everybody has a state rep or state senator. They can come up here and do something. I don't know what ex post facto ability we would have if we see something that's already occurring that is being authorized or allowed to come up and pass a bill or law that would then try to have a civil remedy for it. I don't know how that would work.
Well, that's why the bill's moving forward prospective.
No, I'm talking about if this is if this goes into effect and something comes up where we say, oh, we really wish we could stop this. We really wish the counties could stop this or have a remedy for it. And we then, I don't know that you could pass a bill which would then authorize something that has already occurred for the counties or the hospital districts to go seek recovery of damages.
If I may, Senator Middleton, many of the drug companies were prosecuted by the DEA and the DOJ before Dallas County filed its lawsuit, or Upshur County. They're very limited, even at the federal level, on addressing this type of conduct. It did not go well, and honestly, they didn't get a lot of they didn't get many fines, really, or really much injunctive relief. I feel that the lawsuit that we brought on behalf of all these Texas counties is doing more good for the people of Texas than any of the prosecutions I've witnessed from the DOJ or DEA, as a former prosecutor.
Senators, any other questions for the witnesses? Thank you each for being here. Thanks for your testimony.
Thank you.
No, Senator Perry, the Attorney General's office sent over a document in response to some of the questions. It's being distributed now. And the chair calls Melissa Shannon, Nicole Roostel, Jack Walker, Wendell Ware, Russell Schaffner. Again, we're looking for Melissa Shannon, Nicole Roostel, Jack Walker, Wendell Ware, Russell Schaffner. Welcome. We'll begin over here on my left, your right. Introduce yourself. Give us your testimony.
Thank you, Mr. Chairman. Ware Wendell. I am the Executive Director for Texas Watch. I'm testifying for Texas Watch and for myself in respectful opposition to the legislation. For 25 years, our nonpartisan nonprofit has worked to protect Texas families, and we've been privileged to work with Senator Middleton through the years to protect coastal policyholders. So please understand that my remarks today are focused purely on policy. I have the greatest respect for Senator Middleton personally and professionally, but we have deep concerns about this particular bill. Public nuisance laws protect life and property in our state. In fact, these longstanding legal rights have protected free citizens in the Western world since the 12th century. Yes, before the Magna Carta. We're going back to the time of the Constitutions of Clarendon, which is really the rise of the jury system in the Western world. Enforcement of public nuisance law maintains order by deterring the worst, most widespread harm. We must hold fully accountable those who infringe upon our liberty, whether they're poisoning our body with deadly substances such as those who pushed addictive opioids and devastated so many lives, or poisoning our land through deadly chemicals, toxic chemicals. When communities can't recover their costs from wrongdoers in court, local taxpayers are made to pay the price through tax hikes, and that is not right. Wrongdoers should pay for the harm they cause, not us. The legal restrictions in SB 1034 will only handcuff our local governments, socialize costs, and hurt innocent citizens like your constituents. There's no reason to forfeit our ancient natural rights. And we must, Mr. Chairman, be responsible stewards over creation. In conclusion, I leave you with the following quote from John Adams: "Liberty once lost is lost forever." For the sake of your constituents, your local communities, and Texas taxpayers, we respectfully ask that you protect life, liberty, and property by opposing SB 1034. Thank you.
Thanks for your testimony. Welcome. Introduce yourself and go ahead.
Thank you, Mr. Chairman. Russell Schaffner, an Assistant County Administrator with Tarrant County, against the bill. Tarrant County Commissioners Court is against SB 1034. This bill will limit the county's ability to redress issues in the courts and let juries decide what you can and cannot do according to state law. Regarding previous questions from this morning that the committee had, I was able to get printed our petition for the Tarrant County Hospital District. You'll notice on page 22 of the petition that our number one cause of action is a public nuisance against all defendants. The importance of this is Tarrant County's opioid litigation suit is a bellwether case that is currently pending before a federal judge in Ohio, and it is actively preparing for trial. So we have a case that is ready to be decided on a public nuisance theory, and the federal judge has said warrants continued movement. So I would encourage the committee to consider a couple items regarding SB 1034. If the concern is rogue cities and counties going and filing litigation that could potentially take away the legislature's ability to set laws or to make laws, then there's a very simple fix for this. It's just not SB 1034. The simple fix is to expand the AG's ability to review contingent fee contracts. That would be the simplest way to keep cities and counties from doing it, because a city or a county, and I'll speak for Tarrant County, we don't have the capital necessary to go out and file one of these lawsuits and have the massive litigation. Secondly, perhaps we need to pump the brakes on this particular issue. Let's think about it, watch these cases as they continue on, including Tarrant County's Bellwether case, and see whether or not the public nuisance theory does make it through all the federal courts, so that we can make sure that our constituents are able to get the need and the help that they get from what these tortfeasors have done. Thank you, Mr. Chairman.
Thanks for your testimony. Good afternoon. Welcome. Introduce yourself and go ahead.
Good afternoon, Chair Hughes. Melissa Shannon, Bexar County Commissioners Court, in opposition to SB 1034. Bexar County is a trial plaintiff with civil action for public nuisance against those responsible for the opioid crisis. The cases have resulted in more than $1.8 billion to the state of Texas from 4 settlements so far. This includes $20 million dedicated to the Access for Justice Foundation and more than $1.1 billion dedicated for abatement purposes in the 20 healthcare regions in the state, both rural and urban. Without the public nuisance claims, that abatement money would be unavailable through any other cause of action. Bexar County will receive approximately $22 million in recognition of past opioid expenditures, which our economist estimates will have been more than $162 million over a 15-year period. We received $2.2 million in 2022 and approximately $11 million as a partial payment from other settlements. That money will be used to fight the opioid crisis in Bexar County. When grant funding from the abatement funds available through the Opioid Council, with those funds, we will apply for grants to be used in the county and for the statutory purposes. Of the $2.2 million we received, Bexar County has used more than $1.6 million to increase the number of beds available for women with substance use disorders, provide substance use program coordination in the county and with the city of San Antonio and our hospital districts, like the University Health System that you heard from earlier. Also, to provide Narcan for Bexar County Sheriff's Office to combat overdose deaths. Narcan was recently provided to our sheriff's office, and within less than 2 months was able to save the lives of in excess of 14 individuals who would have otherwise passed without this training. Thank you.
And thank you for your testimony. Welcome. Go ahead and give us your testimony.
Thank you. My name is Nicole Russell. Thank you for having me here to talk about this very important issue. I'm an assistant county attorney in Nueces County, chief of litigation there. I'm testifying on behalf of myself. I'm opposed to Senate Bill 1034. This is a bill that doesn't solve a real problem. It only really creates one. One of the tools used by government attorneys representing the state of Texas, counties, and cities to protect our residents and taxpayers is public nuisance. This is a tool we use in Nueces County. Nuisance actions date back hundreds of years, as you've heard, and were often the only tool landowners and local governments had to protect against dangers to public health and welfare. They have also been used as a method to mitigate against criminal activity, such as prostitution, street gangs, and human trafficking. The idea behind public nuisance laws is that if a private entity causes harm to the public, it's the entity that fixes the problem, not the taxpayers. Under this bill, make no mistake, it would be the taxpayers who end up paying. This bill eviscerates Texas public nuisance law and would effectively prohibit the Texas Attorney General, counties like mine in Nueces, cities, local government, private landowners from protecting their public and private property rights. Not only does it take a tool from our toolkit, but it says the taxpayers are the ones to pay for the wrongdoing of others, not the wrongdoers. Most recently, the Texas Attorney General and cities and counties utilized this law to hold drug companies accountable and others who were responsible for the massive opioid crisis. This has resulted in Texas taxpayers recovering over $1.8 billion. My county alone, any day now, is going to start receiving millions of dollars to help reduce the harms that were created under this because of the opioid epidemic. Do you mind if I continue, sir? Thank you. We need this money received by public nuisance suits to mitigate this harm. If not, these costs get passed to the taxpayer. The AG has also recovered tens of millions of dollars in damages from Juul, the manufacturer of vaping devices that targeted children. Make no mistake, passing this legislation means taxes across the state will have to be increased if we want to take care of these problems that have been created by others. How else would we cover these costs? We need the people who are causing the problems to fix them. When I was growing up in South Texas, I was taught personal responsibility. This bill does away with personal responsibility. It says the taxpayer should pay if a company engages in conduct that harms our communities, regardless of the number of communities affected or the amount of harm caused. This is about fiscal responsibility. I strongly urge this committee to vote against this bill and preserve the important tool that we have to keep homes and communities in Texas safe. Thank you.
Thanks for your testimony. Mr. Walker, welcome. Introduce yourself. Give us your testimony.
Thank you, Mr. Chairman. My name is Jack Walker. I'm testifying on behalf of the Texas Trial Lawyers Association against Senate Bill 1034. I think the questions that should be asked by this committee are, why has this bill been filed and who does it benefit? Because the proponents of this bill make two basic claims. Number one, that there's a problem in Texas, that nuisance claims are or could become out of control. And number two, that the bill is narrowly drawn to address this problem. Respectively, neither of these claims are true. First, there's not a single case or example of a case being filed in Texas under some sort of outrageous or preposterous nuisance claim. And the bill is not narrow in scope. As all witnesses, almost all witnesses have testified, it abolishes virtually all claims of public nuisance. The bill will eliminate accountability to the public for large corporate malfeasance and effectively promotes a form of corporate welfare. The corporate bad actors who cause massive damage to the public through their actions are allowed to keep all the gains and profits from that activity, while at the same time are not held accountable for the damages they cause. It's the taxpayers who will pay the price. Now, what I want to do is provide you some real examples of what's going on right now in the world of nuisance, because nuisance is an active claim that's being utilized to hold corporate malfeasance and bad actors accountable. Just last month, on March 28, 2023, the state of Arkansas sued Meta, Facebook, TikTok, and Instagram, and the lawsuit is based in nuisance, and to hold big tech companies accountable for pushing addictive platforms on our kids and exposing them to a world of inappropriate and damaging content. Just 2 days ago, the Attorneys General of New York, California, and several other states announced a $462 million settlement with Juul. The lawsuit, again, is based in negligence and claims that the company aggressively marketed its e-cigarettes to young people and fueled the vaping crisis. Just last month, the state of Ohio filed lawsuits against Norfolk Southern over the environmental disaster caused when their train derailed in East Palestine, Ohio. Again, it's based in nuisance. May I finish? Public nuisance is the only means that a government entity can use to get monetary harm reduction damages on behalf of the injured taxpayers. The advantage of the nuisance cause of action is you get abatement, and then it is the only real means that the government entity can then get money damages for harm reduction, not just future damages, but money damages to reduce the harm that has been caused. So you've heard a great deal today about the opioid litigation, and I want to finish with this. I'm somewhat uniquely situated in this, Chairman. My firm was part of 3 firms that filed the first opioid lawsuit in Texas for Upshur County taxpayers. Okay, and I can tell you a couple of things from this morning in the questions. Nuisance was our first claim. It is the first, at that time, called a cause of action because Crosstex hadn't really been vetted yet. But it was our first and the main thing that drove that litigation. The second thing that I would tell you is we partnered throughout this litigation with the OAG, with the Office of the Attorney General, in developing and working through the settlements. And I can tell you unequivocally, you've gotten a document today, which is the agreed final judgment and injunctive relief. And I want to read from it because there's claims in this case that they didn't utilize nuisance in the settlement. Under the recitals on page 2, I'm going to read. Plaintiff State of Texas filed original petition complaining of defendants' alleged violations of the Texas DTPA, Consumer Protection Act, and for negligently or intentionally creating a public nuisance. That is in the settlement document itself. Nuisance was what drove that litigation. I can tell you because we were involved and are still involved in that litigation. It's an important cause of action. And again, I would go back to the question, who does this benefit and who does this harm? No one here can say that this benefits the taxpayers of Texas. If you ask that question, you can say you will harm them. The only people, entities this is going to benefit is going to be the corporate malfeasance and those folks who harm the taxpayers of the state of Texas, and then it falls upon their backs to recompense those damages. Thank you. Thank you for allowing me extra time too, please.
Thank you for your testimony. Senators, any questions for the witnesses? Mr. Ware?
Very briefly, Mr. Chairman. My Second Amendment rights are how I protect my family, and I will never surrender those. And similarly, our Seventh Amendment rights, these public nuisance rights, which go back many hundreds of years, are how we protect our communities. And so I don't believe we should surrender those either. Thank you for the additional time.
Sure. Senators, any questions for the witnesses? Thank you each for being here. The chair calls Amy Biffeld. Amy Biffeld, there she is. And Mrs. Biffeld is the last witness we have registered at this time. So if anyone wishes to testify on, for, or against Senate Bill 1034, please make your way to the kiosk outside this room and register. And welcome. Even though we know you, introduce yourself, give us your testimony.
Thank you, Chairman. Thank you, members. I'm glad to have the dubious honor of being the last today. I know it's been a long day. My name is Amy Biffeld. I'm here representing Texans for Lawsuit Reform, and we are in support of this bill. I do want to quickly address a few claims that I've heard today. First, when Senate Bill 1034 says that a product cannot be the subject of a public nuisance action, it's not saying that there is no remedy available if there is a defective product on the market. It's saying that public nuisance claims are not a substitute for a product's liability claim. So the legislature enacted Chapter 82 of the Civil Practice and Remedies Code to address defective products. So that is there in place, and we see that as the appropriate remedy. And then, of course, if it's a deceptive marketing of products, then the legislature has enacted the DTPA, which, contrary to what some other witnesses have said, actually have very steep penalties, such as treble damages found within that chapter. Second, I heard a situation described in Marathon, a refinery leaking pollutants into the groundwater and soil. And I think we hear kind of situations like that a lot, right? A chemical plant which is burning and emitting noxious chemicals into the air, or a refinery leaking into the groundwater. And I want to be very clear that that is not a product's liability claim. That is a water contamination claim. And so that claim can be pursued under the Water Code 7.351 by either the state or a local government entity, or often both. And governmental entities don't need a public nuisance claim here because they already do have a statutory cause of action. And so I do want to kind of describe, because there is a real world situation in which something like this happened, and that was the ITC case, which was in Deer Park a couple years ago, where there was a chemical plant, the ITC chemical plant, which the fire burned for 4 days. It was a horrendous event. And I'll be quick, my apologies. And so in that case, we actually found, okay, what was the solution here? What did they do? Did they plead public nuisance? And it turns out they did not. Harris County and the state jointly filed a lawsuit, and they filed that under 7.102 and 7.351A of the Texas Water Code. And under those provisions, you can seek penalties up to $25,000 a day, so that it is pretty steep penalties. And as Senator Middleton said, if the legislature sees fit to raise these penalties, I've seen penalties up to $1 million in certain bills this session. I think that's certainly something well within your purview. And it was also filed under Harris County local regulation. So my point just being, these horrendous situations happen, and the counties have adequate remedies, and we just see that this is not the appropriate remedy for the counties.
Thank you for your testimony. Senators, any questions for the witness? Thank you for being here. Is there anyone else present wishing to testify on, for, or against Senate Bill 1034? Seeing none, public testimony is closed. The bill will be left pending at this time. The chair now lays out Senate Bill 1367, and recognizes Senator Parker to explain the bill on behalf of the bill's author, Senator Creighton.
Thank you, Mr. Chairman and members. Bringing forward here Senator Creighton's bill today. I'm sorry my voice has gone on me, but look forward to laying this out for Senator Creighton. This was brought to Senator Creighton by a local judge who is concerned that her courthouse employees don't receive the same types of protection afforded to judges, even though they often receive the same types of threats. As my office began working, the project piqued the interest of the Office of Court Administration, with whom we have been working closely to formulate the particulars of the bill. From Senator Creighton's perspective, no legislation currently exists that would also protect the sensitive information of courthouse employees. However, momentum is growing to afford these protections. One of the provisions in the U.S. Congress's H.R. 1776, which was signed into law last December, was the prohibition of government agencies from publicly posting content that includes personal information of an at-risk individual or immediate family member, such as a court employee. Senate Bill 1367 would echo these sentiments, providing confidentiality to our state's court employees and their families, thereby ensuring their safety and security. In particular, this bill would enable court employees to omit their residential addresses from election lists and driver's licenses, as well as prevent the public release of other personal information. Mr. Chairman, there is a committee substitute as well.
The chair lays out the committee substitute and recognizes Senator Parker to explain the substitute.
Thank you, Mr. Chairman. The committee substitute allows court employees to use the same mechanisms to indicate their confidentiality preferences as do currently judges have, by allowing the administrative director of the courts to relay their wishes to the relevant agencies all at once. This committee substitute also redefines the protected group of court employees to include part-time, former, and non-clerk employees, thus protecting all court employees who would find themselves in harm's way. And I believe here, Mr. Chairman, there's some good resource witnesses here as well.
Thank you, Senator Parker. Senators, committee, any questions for Senator Parker? And Senator, do you have questions for that resource witness, or do they have some remarks to make, or do you know?
Good to have them make some remarks.
Good. So as a chair opens public testimony, and as a resource, the chair calls Louis Tomasetti from the Office of Court Administration. There he is. And if anyone else wishes to testify on, for, or against Senate Bill 1367, please make your way to the kiosk outside and register so that we can hear from you. And welcome. Introduce yourself. Tell us who you represent.
Thank you, Senator. My name is Louis Tomasetti. I'm the Director of Government Relations for the Office of Court Administration. I'm here as a resource to speak on the bill, and I have some brief remarks that will provide additional context.
Go ahead.
Perfect.
The bill builds upon Senate Bill 42 from the 85th regular session, which was authored by Senator Zaffirini. Bill clarifies protections provided to judges and expands the protections to individuals whose duties are performed on behalf of the administration of the courts. One of the requirements of Senate Bill 42 was for courts to create court security committees. Those committees and the Office of Court Administration's Court Security Division has identified that administrative positions, such as clerks, are often the recipient of threats. Clerks are the public face of the court and often the first person and the last person that a court participant interacts with. This bill would redact public information published by government agencies that are presently available on the internet for people with ill intent to easily find. I'm happy to answer any questions.
Thank you for your testimony. Senator Parker.
Thank you, Mr. Chairman. Appreciate that. Appreciate the additional context of what this would do and your perspective. That was excellent.
Thank you.
A good sense of the bill. Thank you very much.
Any other questions for our resource witness? Thank you for being here. Thanks for your testimony. Anyone else present wishing to testify on, for, or against Senate Bill 1367? Seeing none, public testimony is closed, and the bill is left pending at this time. Is she here?
You want to do this one? It's just a little painful.
It's an alcohol thing.
Yeah. Okay. Since I'm a no vote, that's probably right.
I can't read. You do
Guys, I can do it.
You might need some of this for your throat.
Yeah, that's what I think my throat needs.
Do I need to lay out a medicine bill after that? Okay. This one
He
better?
gave it to me. I'll do it.
No,
All right.
No. Let me, Brian, let me do it.
No, man, we got you covered.
You sure?
We don't want you to expend that.
Well, it's painful.
We need to hear from you all the time, man. You're that critical.
It's painful for you guys to listen to me.
Chair lays out Senate Bill 242, Senator Middleton, and asks the substitute author of the day, Chairman Hughes, to explain the bill. Is there a sub?
Thank you, Mr. Chairman. And Senate Bill 242 has to do with the vital role this legislature has in ensuring that our 10th Amendment state rights and make sure those powers not delegated to the federal government are reserved to the states. Whatever our policy differences are, we're always going to do better when Texas makes those decisions, when Texas runs Texas. Senate Bill 242 creates a routine procedure for review of federal agency rules that are adopted in response to unilateral presidential executive orders and provides the status of any litigation regarding a rule based on an executive order, including whether a court has found such rules to violate constitutional rights. The bill requires a monthly report to the Lieutenant Governor, the Speaker, and the Legislature regarding executive order-based rules adopted by federal government agencies that relate to certain subject matters. Those matters are pandemic response, natural resources, agriculture, the use of land, financial sector standards, border security, transportation, the Second Amendment, or free exercise of religion. The report also has to include the status of any lawsuit filed relating to a rule identified by the AG report under this section, and whether a court has found the rule to violate rights guaranteed to the citizens of the U.S. under the U.S. Constitution. And finally, the bill prohibits state agencies and political subdivisions from cooperating with a federal government agency in implementing an executive order-based agency rule that was found by a federal court to violate the rights guaranteed to the citizens of the U.S. by the Constitution. This bill helps prevent a hodgepodge and patchwork of executive order implementation around the state. It also encourages a separation of powers between the legislative and executive branch. Congress should be legislating and not relying on unconstitutional executive orders to make general law. This bill is focused on protecting individual liberties and private property rights of Texans. And I do have a substitute, Mr. Chairman.
Chairman Hughes sends up the committee substitute for Senate Bill 242, explaining the difference between the sub and the bill as filed.
Thank you, Mr. Chairman and members. This substitute replaces the language of the introduced version with the same language from House Bill 3046, which passed the House 95 to 50 and passed this committee 6-2 last session. The committee sub matches the language of last session's bill exactly, except for the inclusion of border security and transportation on the list of issues covered by executive orders that the AG shall review. That's what substitute does.
Thank you. Any questions for the bill author? Chair calls up invited witness Chuck DeVore. Chuck DeVore.
There he is.
State your name, who you're with, position on the bill in 2 minutes, please.
Thank you, Mr. Chairman and members. My name is Chuck DeVore. I'm here on behalf of the Texas Public Policy Foundation in support of Senate Bill 242. I think it's important for members to appreciate and to understand that without the enforcement authority of state and local governments, the federal government is virtually powerless to work its will on the states and on the people. There's approximately 1.2 million state and local law enforcement personnel versus about 137,000 at the federal level. And so the challenge that we've been seeing that's especially accelerated in the last 10 or so years has been the strategy that we first heard in the presidency of President Obama that was called the pin and the phone strategy, using significant use of executive orders when the president was unable to get Congress to move on the president's priorities. And by using these executive orders, frequently these orders, of course, would then be subsequently challenged in the courts and would eventually work their way through the system. But the challenge then being that in certain key areas, the 8 specific areas enumerated in this bill, that there can be a significant amount of harm that could be caused as states are then forced to comply with an executive order that, to be clear, has not been passed through both chambers of the federal Congress nor signed into law. So what this bill would do is, if any court then finds that an executive order is unconstitutional, it allows the Attorney General to enumerate these specific instances around the country and to then make a report. Then that would allow Texas to then act not to enforce these executive orders that have been found to be unconstitutional by a federal court. Now, some critics have likened this to nullification, which of course it is not at all like the situation that led to the nullification crisis in 1828 through 1832. The big difference, of course, being is that that was in response to a duly passed federal law, not an executive order, and it also involved the threat of violence from a state that was preparing to call out its militia to, in this case, prevent the enforcement of a tariff that was duly passed by Congress. So again, just to be clear, we're talking about executive orders here that have been found to be unconstitutional by a court. So I think there's a significant difference. I think that the benefit to Texas and to its citizens would be an expedited following of the Constitution and of their individual rights and states' powers. Thank you, members.
Any questions for the witness? Senator Paxton.
Could you repeat, maybe, and I don't know if you were looking at written remarks, but
no.
You, at the very beginning of your remarks, you said without the local.
Right.
Could you repeat that?
Yeah. So what's? Thank you. Thank you, Senator, for your question. One of the things I've found to be very interesting is what's been happening with increasing.
Do you remember the sentence?
I remember what you're referring to. Yes.
Okay. Can you just try to restate that thought? That's what I'm asking.
Sure. All right. So there are approximately 1.2 million state and local law enforcement personnel full-time, compared to 137,000 at the federal level. And so what has happened is that the federal government has frequently appropriated the policing powers of the state and local governments to do their job, for which, without them assisting, there's no way that the federal government by itself can enforce all of these edicts that come down from the federal level.
That's the statement. Without the cooperation of the state and local authorities,
Correct.
the federal government is really powerless to impose these acts.
They have 11% of the law enforcement personnel, as do the states. Now, of course, one of the ways that they pull the strings is that through deficit spending, they provide significant portions of funding to the state and local governments, and certainly through an act of Congress could say, well, if you don't comply, then you won't get the money. Probably less so with an executive order.
One question. The brevity of the reports monthly, that's a pretty tight window, and honestly, I hope we don't have that many executive orders to have to worry and report with, but is that the right number, or should it be quarterly? Is the brevity because executive orders sometimes takes immediate? I mean, what's the logic behind a monthly and not a quarterly? Or some other?
Senator, that's a great question. I would argue that in today's day and age, with the ability to rapidly search things through the internet, with the fact that executive orders are in fact relatively, in normal times, are relatively infrequent.
Right.
But they're certainly all posted to a site connected with the president, with the executive branch. And then, of course, it's pretty easy to then find just through using the internet tools that we have, the instances where judges have ruled.
I think you know about them. The question is, just because you know about them and put them in a report, are you going to be able to respond to them any quicker? So I guess what I'm saying is it's nice to know, and it's good to report, and it's good to have the information. But if the AG's office is probably like all of our state agencies, they're backed up, they may not can get to it for a year. But I'm not really disputing the frequency per se, but I just know quarters and business cycles and things. But this is unique to a specific action, so I'm okay with the month. I'm just saying you're putting something on a tight window that's going to be publicly kind of an awareness point, and that didn't expand the capacity for the AG to respond. But the quicker you know about it, the better it is. So I get it.
If I may, just to cite one specific instance from the recent response to the pandemic, you had the case of the Centers for Disease Control issuing a moratorium on evictions. And of course, if you're a small property owner and you're basically month to month on your ability to generate income to pay your loans, and a federal agency then issues some guidance that prevents you from being able to collect revenue from your properties, I would argue that every month counts in that instance, and that would presumably allow a more quick response to preserve people's rights, to preserve their property against what in this case was an unlawful federal edict.
Right. I hear you. Any other questions, members? None? Thank you for being here. Chair opens up public testimony. Chair sees one wanting to testify publicly, Richard McKenzie. If there's anybody else wishing to testify publicly that have not registered, please do so while Mr. McKenzie's at the table. Is Richard McKenzie available? Richard McKenzie going once, going twice. We'll show Mr. McKenzie as for the bill, but not testifying in public. Is there anyone else wishing to testify on, for, or against Senate Bill 242, committee substitute for Senate Bill 242? Chair is none. Public testimony is closed. The bill will be left pending. Chair recognizes Chairman Hughes. Is that your bill or somebody? Menendez. Senate Bill 1322, Senator Menendez bill with Chairman Hughes laying it out on his behalf. Please explain the bill.
Thank you, Mr. Chairman. I'm pleased to present on behalf of Senator Menendez Senate Bill 1322. It relates to vintage distilled spirits and the ability for these spirits to be sold into the marketplace. And we do have a committee substitute, Mr. Chairman.
Chairman Hughes sends up committee substitute Senate Bill 1322 and asks Chairman to explain the difference between the committee substitute and the bill as filed.
Thank you, Chairman. The committee substitute creates a process to allow a private Texan who has a collection of vintage distilled spirits, to sell these spirits to a Texas package store that allows the package store to market and sell vintage distilled spirits. This bill applies only to vintage distilled spirits, and the committee substitute encompasses a couple of changes after speaking with both the Texas package stores and the Texas Alcoholic Beverage Commission. And there is a businessman here who can, an avid collector who can testify as invited testimony. There's also a resource from the Alcoholic Beverage Commission, and that's how I explain the bill on behalf of Senator Menendez.
Any questions for the author? Is Philip Browning invited?
Oh, yes, thank you.
Chair invites Philip Brown, invited witness. Philip Brown. Fill out Ferris Bueller. Is Philip Brown still present? All right. So, Daniel Gonzalez for public testimony. There you go. All right. State your name and who you're with in 2 minutes and position on the bill.
Thank you, Senator. Mr. Chairman. I love our substitute author for today, so thank you, Mr. Hughes, for laying it out. My name is Daniel Gonzalez. I'm here in support of Senate Bill 1322 on behalf of Philip Brown. He was here this morning but had to go back home and take care of family business. But we are supportive of the bill. We're supportive of this free market bill. It would allow, as Mr. Hughes stated, for vintage distilled spirits to come back into the third tier with the package stores. The committee substitute that's in front of you this afternoon reflects months of work working with all the stakeholders as well as working with TABC to get all of their comments. So we believe what we have in front of you this afternoon is an agreed-to bill, and it's going to be good for Texas, good for Texans who have vintage distilled spirits. So those spirits can stay here in Texas and not be shipped elsewhere across the U.S.
Thank you for that. Any questions for this witness? Thank you for being here.
Thank you.
I do have a resource witness from TABC if anybody needs a resource witness. Everybody good? All right. Is there anyone else wish to testify on, for, or against committee substitute Senate Bill 1322? Chair is none. Public testimony is closed. The bill will be left pending.
That's right. That's it. Thanks, Mr. Chairman. Is there any other business to bring before the Senate Committee on State Affairs? Seeing none, the committee stands in recess, subject to call of the chair. Thank you all very much. Good afternoon.